A Supreme Court ruling changed the rules of the road for gun laws in a way most people still don't get. And if you follow the old rules, you can still get arrested, even when you think you're right. Quick question before we continue. Are you subscribed? Because what I'm about to share could keep you from making a life-changing mistake. Hit that button now so you don't miss the next legal update. All right, here's what just happened and why it feels like the ground moved under gun owners and lawmakers at the same time. Most gun owners think gun laws work like this. The government passes a rule and you just obey it. But the Supreme Court basically said, not so fast. Show us the history. That big shift came from New York State Rifle and Pistol Association versus Bruin. In plain English, the court said, you have a right to carry a handgun in public for self-defense. And it struck down New York's proper cause rule, which made people prove a special need to carry. In other words, I want to protect myself was not good enough for them, and the court said that was unconstitutional. Now, the part that shocked me was not just the carry result. It was the test the court told judges to use. The court told lower courts, don't balance public safety versus gun rights like a scale. Instead, ask a different question. Does this modern gun rule match America's historical tradition of gun regulation? That sounds academic, but it's not. Because once you force the government to prove history, a lot of modern laws start looking shaky. And then the court doubled down on how this history test is supposed to work in United States versus Rahimi. Rahimi was about a federal law that temporarily disarms people under certain domestic violence restraining orders. The court said that kind of disarmament can be constitutional when a court has found a credible threat to someone's safety. And it compared that to old surety and going armed laws from history. Here's why Rahimi matters to you, even if you're not in that situation. Rahimi tells lower courts, stop hunting for a perfect copy from 1791. The court said you don't need a historical twin. You need something relevantly similar, meaning similar reason and similar burden. So now we have a new world. Bruin says, you can't make normal people prove special need to carry. Rahimi says, history analogies can be close enough, but the government still has to justify them. Now, this is where it gets interesting. Because right after Bruin, lawmakers rushed to pass new laws. They tried to rebuild the old walls, but with different bricks. And that's where these collapsing gun laws come in. When I say collapsed, I mean courts across the country have been striking down, blocking, or narrowing these laws using the Bruin test. Not everywhere, not forever, and not in every case. But enough that millions of gun owners are living under rules that could change fast. First thing that collapsed after Bruin. May issue carry permits that require special need. This is the clearest one because Bruin directly hit it. If your state or city basically told you only the rich, connected, or threatened people get permits, that model took a major blow. Here's a real-world scenario. You're a normal person. You work late. You stop for gas at midnight. You apply for a permit and say, I want self-defense. The government says, that's not enough. Bruin says that's the problem. The right is not only for people with special stories. Second thing that started collapsing, everything is a sensitive place. Maps. After Bruin, the court said there are some sensitive places where guns can be banned, like schools and government buildings. But the court also mocked the idea that a state can say a whole giant area is sensitive just because it's crowded. So what did some states do? They tried to label huge lists of places as sensitive: parks, trains, Times Square type areas, museums, stadium zones, sometimes whole blocks. And courts have been pushing back in a lot of those fights because Bruin warned states not to turn the entire public square into a no-carry zone. Third thing that began collapsing, default no-carry rules for ordinary public life. This is the part nobody's talking about at family dinners. Some laws don't say guns are banned everywhere. They do something sneakier. They say you can carry only in the small number of places the government allows, and the rest is basically off limits. That's a big deal because it can turn you into a criminal while you're doing normal stuff. Imagine you're driving, and you stop at a coffee shop, then a grocery store, then a pharmacy. 3 normal stops. But if the law says those places are all restricted, your right to carry becomes a right you can't use. And Bruin's logic is simple here. A right that exists only on paper is not much of a right. Fourth thing that started collapsing. Extreme private property carry bans. Some laws tried to flip the default rule. They basically said, if a store does not post a sign, carry is banned. Most people think, no big deal, I'll just look for signs. But you can't always see a sign. What if it's inside the door? What if it's tiny? What if the sign is only in English and you don't read it well? What if you're walking in with your kids and you miss it? Now your whole day can become a legal trap. Courts have been wrestling with whether that kind of default ban fits history, because the government has to show it matches historical tradition, not just modern preference. Fifth thing that started collapsing, creative licensing rules that punished normal people. After Bruin, many states kept permits, but they tightened everything else. They added extra interviews, long delays, expensive steps, and broad good moral character style rules. Now, I'm not saying every permit rule is illegal. Bruin itself said many states use objective shall issue style permits. But if a permit system turns into a slow, expensive maze that blocks normal people, courts may treat that like the old proper cause problem. So what's the real-life risk? You might think your permit application is just pending, but the state treats your carry as illegal while you wait, and waiting can be months. Sixth thing that collapsed, and this one is 100% Supreme Court clear: the federal bump stock ban rule. In Garland versus Cargill, the Supreme Court said the ATF exceeded its authority when it classified bump stocks as machine guns. In simple terms, the court said, with a bump stock, the trigger still resets between shots, so it does not fire more than one shot by a single function of the trigger. And it's not automatic in the way the law requires, because the shooter still has to keep doing certain physical actions. Now, don't make this mistake. People hear that and think, so bump stocks are legal everywhere now? No, states can still regulate them, and Congress could change the federal statute, but the specific federal rule that treated them as machine guns under that definition got knocked down. And to notice something important, Cargill is not even a Second Amendment case. It's a who has the power to do this case. That matters because it shows another way gun rules can collapse, not because of the Second Amendment, but because the agency used the wrong tool. Seventh thing that is collapsing in real time: one-size-fits-all disarmament rules that don't match the reason and burden idea. This is where Rahimi matters. Rahimi upheld a specific law in a specific setting, but it also gave a roadmap. It said the government can disarm someone when a court has found a credible threat, and the restriction is temporary and tied to that finding. So if a law tries to disarm people with no individualized finding, no real process, and no clear time limit, challenges get stronger. Because courts will ask, where is the historical match, and is the burden comparable? Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. And before you think this is all good news or all bad news, let me tell you the truth. The Supreme Court is not simply rubber stamping every gun rule or striking every gun rule. It is forcing a different kind of argument. Here's a hypothetical example. Imagine two laws. Law A says, if a judge finds you are a credible threat to your partner, you cannot have a gun for the length of the order. That looks more like Rahimi's world, where the restriction is tied to a court finding and is temporary. Law B says, if you're accused of something with no hearing, you lose your gun rights for 5 years. That's a much harder fit under Rahimi's reasoning, because the process and the burden look different. See the difference? It's not guns always win. It's prove your rule fits the tradition and the logic. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you. Subscribe so you don't miss it. Now let me zoom in on the part that can protect you in real life. Because most people don't get in trouble at the gun store. They get in trouble during normal life. Picture a traffic stop. Your taillight is out. And the officer walks up and asks, do you have any weapons in the vehicle? Most people think the danger is only what you say, but the bigger danger is what location you're in. After Bruin, a lot of states tried to create new restricted place lists, and courts have been slicing those lists up. So your job is not to argue with a cop about Bruin. Your job is to stay out of the trap. Here's what most people get wrong. They hear, this law got enjoined. Then they carry like the law doesn't exist, but injunctions can be partial. They can be paused by appeals. They can apply only to certain plaintiffs. First, know your exact state and local rules today. Second, assume viral legal news is incomplete. Third, do not carry in places that are clearly restricted everywhere, like federal buildings. Bruin did not create a free-for-all. Now, let's talk about the agency rule collapse side, because Cargill is a warning shot. Policy often comes through agencies. Cargill showed that when an agency stretches a statute past its words, it can lose. The court kept coming back to the text, like single function of the trigger, and refused to rewrite those words. And that connects to another case, Bondi versus Vanderstock. The court said the ghost gun rule was not facially inconsistent. This proves something important. The Supreme Court is not always for or always against regulation. It's asking, what does the law actually say, and what does history actually support? So if someone tells you the court ended all ghost gun rules, that is not accurate. Vanderstock went the other direction. This matters because millions of people buy parts without realizing the rules may still apply. Don't be the test case. Hey, 73% of people watching aren't subscribed. Join the gun owners who get these updates first. Click subscribe now. Here is the simple takeaway. Bruin attacked the special reason model. Courts are attacking laws that try to bring it back. Bruin warned against declaring whole cities sensitive. Cargill showed agencies cannot turn one category of item into another. Rahimi showed disarmament laws need a strong reason. Vanderstock showed some regulations survive when the wording supports them. All of this can be true at once. One rule collapses, while a similar rule survives elsewhere for years. Verify your current rules. Stop trusting viral clips. Subscribe now because the next video explains what to do before deadlines hit. The Supreme Court changed the test used to judge gun rules. That's why whole categories of laws are getting blocked quickly. If you got value, stay with the community. I'd rather you hear the update here than learn it in handcuffs. Final legal disclaimer. I'm not your lawyer, and this is not legal advice. Laws vary by state and rulings change. For your exact situation, talk to a qualified attorney in your area. Thanks for watching, and stay safe.